Okay, I'm Henry Quillian. I'm here at Taylor English Duma with my colleagues. I've got quite a number of colleagues in the room with me and a number that are on the web with us. Thank you for attending. Today's topic is actually one of high anxiety in my mind. It's the rule O.C.G.A. 91168, which is a Georgia statute found within the Civil Practice Act. It is associated with the ability of parties being able to recover attorney's fees depending on whether they take certain actions during the course of litigation. For those out there in the world, you need to know we are not providing legal advice to you at Taylor English Duma unless we are engaged to do so. And this is for your information, for your consideration, for your deliberation and discussion with your own attorney. We encourage you to get an attorney if you find yourself in a situation involving any topic that we talk about here in litigation fundamentals. And we do encourage collaboration among the people that are present, as well as questions from the people who are online, so that we can make this an interactive experience. O.C.G.A. 91168 came about initially in 2005 when they were doing tort reform in Georgia in a major way, and apparently it was thereafter revised in 2006, but it's been around for quite a while. People have been utilizing it, trying to test the waters with it, find out what its breadth is, what can be achieved with it, and what cannot be achieved with it. And it also has a little known and little talked about, in my view, subsection E, which is a sanctions section for frivolous litigation. So let me just throw out a couple of the topics we'll discuss today, which frankly, some of them were new to me that we're going to be going over. One, recent 11th Circuit case has found again, I guess is one way of putting it, that even though the statute specifically refers to shifting attorney's fees in tort cases, it actually can be used to shift attorney's fees in cases that have both mixed tort and other claims if the underlying facts that would give rise to the liability under one theory are the same, or as they say, entirely the same as the facts that would give rise to liability under another theory, such as breach of contract. So in that respect, the court cases tend to expand the liability a little bit broader than what might be obvious from the statute. Secondly, something I learned, which is it is considered to be a substantive law, even though it is found in the Civil Practice Act, and therefore it can be utilized if you're litigating Georgia law cases in federal court. And it's been found that Rule 68 under the Federal Rules of Civil Procedure does not preempt 91168 claim, even though they are very similar in nature. The Rule 68 is the offer of judgment in federal court, and in the state court, it is an offer of settlement or an offer of judgment, and it has its own rules. Next, it turns out that in a very recent Georgia Supreme Court case, it was found that you can recover under both O.C.G.A. 13611, which has to do with stubborn litigiousness causing unnecessary trouble or expense, or bad faith in the underlying transaction that precedes the litigation, and under O.C.G.A. 91168. So it's potential and is not inappropriate, according to the Georgia Supreme Court, for a plaintiff, to both get their full attorney's fees under 13611 and their full attorney's fees under 91168, or at least a great portion of their attorney's fees. So theoretically, if you had a plaintiff's case on a 40% contingency, you could get whatever your verdict is plus 80% of your verdict all over again under the combination of these statutes. And I've been back and forth with some of my plaintiff friends this morning. Of course, I do plaintiff's work too. And they take the position that under 91168E or alternatively 91514 or 51780, because those actually apply to frivolous litigation, that you theoretically could triple your attorney's fees. You could get them 3 times in addition to the verdict if you were successful in triggering all those statutes. You will see, however, that 91168E is expressly says if you bring in 91168E sanction motion, you can't also do it under O.C.G.A. 91514 or 51780. So basically, there are a lot of surprises in this statute. I've actually entitled this conversation Fire and Ice because this statute can be used to either, if you're a defendant, potentially put ice on or really quench a plaintiff's claim by putting the plaintiff in extreme mental distress, for lack of better description, over whether they should settle at an offer being given by the defendant for fear that they may end up paying the defense attorney's fees at the end of the day if they do not succeed to a certain degree. Or it can be used by the plaintiff to put the fear in the defendant that it will double the attorney's fees or potentially triple the attorney's fees that might be recoverable by the plaintiff if the plaintiff does really well in the litigation, significantly better than the settlement offer that is offered under 91168. So under those circumstances, obviously it triggers, and I guess this is what was intended by the legislature in 2005, it triggers real heart-to-hearts between the attorneys and their clients, because under this particular statute, only the clients can be liable for these attorney's fees that are incurred under this statute. So, you know, if you're representing a not particularly well-heeled plaintiff and they have a claim they think is really good, let's say worth $1 million, but they get a $250,000 settlement offer, but yet it's being defended by a humongous law firm that could easily run up $1 million in attorney's fees. Does that plaintiff want to take on the risk of having $1 million judgment against them by reason of bringing their $250,000 to $1 million plaintiff's case? And that's exactly what can happen if this statute is pursued to the nth degree, and also all the necessary steps are taken. So I have distributed to anybody that's within the firm O.C.G.A. 91168. For people that are out there online, you can Google it, O.C.G.A. 91168. Just make sure you have the current version of it. And I'll just sort of generally outline what this statute is, how it works, and then we will go into some of the details of it. So basically, it allows either party after 30 days subsequent to the service of the summons and complaint. In other words, it could be done with by the defendant on the last day of filing the answer plus 1 day, to serve a settlement offer on the opposing party in what it says are tort claims. So it says to settle a tort claim for the money specified in the offer. And so on its face, everybody thinks, well, this relates to tort claims. And those of you that are out there, all the lawyers here, of course, know what tort claims are, but they are claims that are generally negligence, fraud, some sort of statutory tort, trespass, nuisance, all those things where there's a duty that is breached by the person you're complaining against, and you're damaged because of their breach of duty, and you claim they caused your damages, so you have the right to recover. Now, so obviously in the earlier stages of the use of this statute, it was used principally for trying to get probably the most numerous types of tort claims that are out there, personal injury claims, settled. And so what does this offer the opportunity to do? So basically, the person who wants to put the other side in jeopardy by reason of serving a settlement offer under 9/11/68 has to craft a carefully written, and we can talk about some cases where somebody didn't quite write it carefully enough, settlement offer to the other side, offering to settle the case for a certain amount of money, or alternatively, with some other conditions within the settlement. And typically, in light of the fact it's a tort case, it would include money. Let's just go through the 9/11/68A requirements for a settlement offer. First of all, it must be in writing. It must be stated that it's made pursuant to this code section. It has to identify the parties making the proposal and the party or parties to whom the proposal is made. In other words, if there are multiple plaintiffs and multiple defendants, one plaintiff could make it to one of the numerous defendants, or vice versa, or it could make it against more than one defendant. It has to identify generally the claim or claims the proposal is attempting to resolve. So it could be, all right, I have a breach of contract case against you and a tort claim, and I'm going to offer to settle only the tort claim. And I'm going to do it only against you, not against you and you. It has to state with particularity any relevant conditions. Conditions can be of the nature of, if you're the defendant, you're making it to the plaintiff, you say, and you will dismiss the case with prejudice within 10 days of payment of the money that is being offered under this settlement. That would be a type of a condition. Another one you'll see that comes up in the case is that there's a co-pending injunctive relief action. The party may say, and you will also dismiss the case, thereby giving up your injunctive relief claim, which apparently, nevertheless, even though you have an equitable claim and a tort claim under certain circumstances, the statute is still good for the attorney's fees incurred in both pursuing the injunction and the tort. Okay, you have to state the total amount of the proposal. And then we get a little bit more driven, a little more detail. You have to state with particularly the amount proposed a claim for punitive damages, if any. So if you have a tort claim where you're claiming punitive damages, you could say, I'm not intending to settle the punitive damages. Or you could say, this settlement will cover all the punitive damages that are sought in the action. And also you have to state whether the proposal includes attorney's fees or other expenses, and whether the attorney's fees or expenses are part of the legal claim. So we were talking about 13.611 earlier, O.C.G.A. 13.611, which is recently determined by the Supreme Court, well, a long time determined, but recently repeated, that it is a separate tort claim. O.C.G.A. 13.611 is a separate tort claim that nevertheless is dependent upon the success of an associated claim. And that is a claim that you could either say you're going to settle in your 9/11/68, or I don't know how you would settle the underlying compensatory damages without settling the attorney's fees, but nevertheless, you have to state whether you are settling your attorney's fees and expense claim or not. And you have to serve this sort of like a pleading, except for with additional ramp up in means of communication. You have to attach a certificate of service. You have to say who you're serving, and you have to send it by certified mail or statutory overnight delivery, which is essentially FedEx, UPS, other recognized statutory overnight delivery carrier, as required by O.C.G.A. 911-5. So it's fairly detailed on what you have to put into your offer, and it's detailed in how you have to construct it and how you have to send it. But so what is the goal of this? Is this goal simply to make a settlement offer, or is it got extra punch to it? Well, it's got extra punch, as I mentioned. So here, if you're the defendant, you have to try to contemplate in your mind, what amount can I offer such that it's not very probable the plaintiff will achieve at least 75% of my offer against my client. Because if you make an offer and the plaintiff does not, and the final judgment obtained by the plaintiff is less than 75% of such settlement offer, then the defendant can say, okay, plaintiff, you're going to pay me all the attorney's fees I spent going through the litigation associated with your claims. And that is you will see in O.C.G.A. 91168 D1, it says the court shall order the payment of attorney's fees and expenses of litigation upon receipt of proof that the judgment is one to which the provisions of paragraphs 1 and 2 of section B apply. So it's if you trigger this, it's a mandatory order from the court if it is brought to the court's attention that this settlement offer has been made during the course of litigation. And it covers the attorney's fees that have accrued since the time 30 days expired after the offer was delivered. So in this particular type of offer, the offer is made, the responding party has 30 days to respond, and there's a specific means by which the respondent has to respond. And then after that 30 days expires, then the attorney's fees and expenses that are thereafter experienced by the party who's making the offer become eligible for recovery under the statute. So we've talked about the fact that the defendant can send this. And so when would it be a good, if the defendant has the ability to size up the plaintiff's claims real early on, when would be a good time for the defendant to send a well-crafted and considered settlement offer under 91168? Early. Why would you send it early?
Run up the tab.
Right. So after 30 days, which is probably when depositions are going to start and all that, the tab's already starting to run against the plaintiff if the defendant ultimately is successful in getting a judgment against it less than 75% of the settlement offer. So for instance, if the defendant wins summary judgment, well, that's easy. That's going to be definitely less than 75% of the settlement offer, right? And if the defendant manages to, even if there's a verdict against the defendant, get an amount that's less than 75% of the settlement offer, and they also trigger the statute. So for instance, a plaintiff who believes they have $1 million claim could win, and a defendant offers $400,000, and then the plaintiff only wins $299,000. They could end up paying $1 million to the defendant for attorney's fees after a trial. So they end up net minus $701,000, let's say. So if the defendants had $1 million of attorney's fees. So is that fire or is that ice? Well, it's supposed to put ice on plaintiffs' cases. There's no doubt that's what the legislature wanted to do. And so, like I said, there has to be heart to heart if you're representing the plaintiff in that scenario, and it's not a well-heeled person that has the ability to pay a very large law firm's legal fees. Do you want to continue with this? Because if you do, you might end up having to file bankruptcy at the end of the day, if you lose, okay? So the plaintiff also has this opportunity, and I've used this, I've been subjected to this in a plaintiff's case where the defendant made offers against my client, credible offers that were, reasonably tempting. And then I've also, as the plaintiff, made these settlement offers against defendants that I wanted to bring to the table as rapidly and at as high amount as reasonable as I could, where I knew that the plaintiff's claim were not perfect. They were just pretty darn good. So the plaintiff can make an offer to the defendant, same type of thing. They have to go through all the different steps make sure all the T's are crossed and I's are dotted, make sure it's served properly, can make an offer to the defendant saying, okay, pay me this amount of money and I'll dismiss my case, my tort case against you. And for the plaintiff to ultimately trigger the statute, the plaintiff has to achieve a verdict and ultimately get a judgment entered that is over 100, greater than 125% of the offer. So this statute provides a good opportunity for a plaintiff's lawyer to have some real heart to heart before making an offer with their client about, okay, what's a reasonable assessment? If you ring the bell in this case, what's the largest judgment you're likely to get by reason of a verdict? And should we back off that by dividing that amount by 125% and come up with a settlement offer that is maybe marginally less than 100 than that number, and make it as a settlement offer to the defendant, so that, hey, you know, you're going to have expert witness costs, you're going to have all these attorney's fees, and you're going to have the deposition costs, transcripts, and all that. Yeah, should we go ahead and trigger this and make the defendant nervous about paying this extra money? Okay, so let's assume this is a plaintiff and it's in a car wreck case. And plaintiff makes an offer that is well considered for an amount of money they'll settle their case for, a serious injury case, but you know, the person's recovered and maybe they have some things that are known to the plaintiff's lawyer that aren't particularly attractive to a jury, like maybe the person's a pedophile or something. They were seriously hurt in a car accident, but they're a pedophile. So there may be some something that's going to make their case, no matter how badly injured they are, less attractive. So you make a settlement offer to the defendant, and then, however, the defendant does not respond. There's a 30-day response period. If the defendant does not respond, that's considered to be a rejection. If the defendant counteroffers, whether under 9/11/68 or not, that's considered to be a rejection. And so offers made to the defendant rejects it, whether by not responding or actually by sending a counteroffer. What happens if the plaintiff wins more than 125% of the offer? It triggers a statute, so they have the right to get a move to the court, show the court that they made the offer, that it was triggered by the verdict. They have the right to recover attorney's fees. What happens to the defendant in a car wreck case if that happens? The defendant's going to have the verdict against it for the however much the plaintiff wins, right? And there's going to be a separate award of attorney's fees and expenses. Does car insurance cover attorney's fees incurred under 9/11/68? What do you think, Frank? Under what basis would it be recovered? I've never seen an insurance policy that says we, the insurance company, will pay your attorney's fees because you turned down an offer.
But don't you, if you demand that your insurance carrier settle for that amount, and they
Aha. So that means that maybe a defendant in a car wreck case needs to have somebody who will advocate with their insurance company against the insurance company. Is the insurance defense lawyer likely to do that? How many insurance defense lawyers turn around and make demands against the carriers that they work for? I see at least some shaking heads. I won't mention any names here. So that means the defendant needs to think about, well, maybe I need to get a separate lawyer to represent me to make sure that I don't have attorney's fees that aren't covered by insurance rendered against me at the end of the day. Now, am I giving an opinion that a car insurance carrier who has hired an attorney who has turned down a settlement offer, and where the carrier has not come forward with the money to pay it, have I made an opinion that that's not going to be covered? Well, if it's $20,000, miraculously it might be covered by the carrier. If it's $1 million and the person has a $35,000 insurance policy, chances are it's not going to be covered. So, but that puts the defendant in the car wreck case in a bad way if they get a big judgment against them for attorney's fees, and their insurance carrier doesn't cover it. Okay, so there is a provision here that says if an offer is made, I'll just read the first lines of 911-68A so you can see what it says. It says, at any time more than 30 days after the service of the summons and complaint on a party, but not less than 30 days, in other words, you have to wait, not less than 30 days before trial, okay? So there's a back-end limitation on this as well. So if you're the lawyer that wants to make this, you have to predict when trial might be, and you need to make sure that your offer is made far enough before trial. But it says, or 20 days if a counter offer. So if trial is set and you get an offer under 911-68 and you want to make a counter offer and trigger it against the opposing party, you better make your counter offer within 20 days before trial so that you can trigger it back against them. And then everybody's in jeopardy going to trial for whatever is incurred during the trial for attorney's fees, although the plaintiff, whoever makes the first offer, is going to have a little bit better stance than the one making the counter, because there still has to be the time elapsed for the counter offer, right? And so basically you got a situation where you got the potential for both parties setting up the other party for a recovery of attorney's fees under this statute. Now, other things that can happen. First of all, after the trial is done and the statute has been triggered, then the party that wants to recover the attorney's fees needs to tell the court about this, because this is a settlement offer. And it specifically says that you do not send the 911-68 offer to the court, which makes sense, during the time that you're making it. So therefore, you have to have it in your trial box, right, along with your certified mail receipt, so that when you get the verdict that you're going to try to move upon, you can tell, hey, Your Honor, we made a 911-68 offer way back when, and since that time, we have incurred a gazillion dollars of attorney's fees and expenses, and we want an order from you. We demand an order from you because it's the statute says shall order for our attorney's fees and expenses, and you have to be prepared to prove those up. And how are these attorney's fees and expenses most often proven? By a party who is represented by an attorney in a court setting.
Bring in the bills and the attorney testifies reasonable and necessary.
That's right. So you have the bills, and then somebody that's deemed to be an expert, which often is the attorney representing the party. That's been decided in Georgia, that the very attorney who made the bills can also testify that they're both reasonable based on the rates they charge, the amount of time they spent, et cetera, and necessary for the litigation that was taking place. And you could separately hire an expert and have that person teed up and ready to go, a third party who comes in and says, I've got an extreme experience. I've looked at 1 million cases. This attorney's work was wonderful and it was reasonable and necessary, but most of the time it's actually presented by the attorney themselves. And then what does the opposing party need to be prepared to do? if the attorney is going to testify regarding how perfect their billing was and how efficient they were in the presentation of the case and how they didn't do anything that was unnecessary or a pursuit of the case. Well, if you have somebody testifying against your client trying to get a lot of money, what do you need to be prepared to do as a trial lawyer? Cross-examine the person. And why would you want to be able to do that? Well, under 91168D, first of all, you want to reduce the amount, try to convince the court that either they really incurred all those fees before the offer matured. That would be a pretty straightforward one, right? The time hadn't expired. You need to chop off everything that happened before this time. Two, you want to say, well, they ran round and around in circles doing unnecessary work, or they're charging some outrageous amount of money per hour. And you could bring in evidence of that particular jurisdiction's market for attorney's fees. If somebody from Atlanta goes down to small town South Georgia, the attorney down there may say, well, $1,000 an hour is not what we charge down here, you know. But also there's the opportunity under 91168D2 for the party opposing the attorney's fees award to say, now, wait a minute, that offer that was made, even though they ultimately triggered the statute, that offer was so low that it could not have possibly been made in good faith. The only reason why that offer was made was with the prayer that they would convince some dim-brained juror to vote against them and prevent a verdict in my client's favor. And at the time it was made, the offer was not made in good faith. And then under that circumstances, it says the court may disallow an award of attorney's fees and costs. So it's potential for either party, plaintiff or defendant, to set up the other side using a settlement offer, get all the way through to the point of triggering the statute, making their presentation regarding the amount they ought to recover, and the other side to say, now, wait a minute, the offer was just not in good faith. It was ridiculously low. This person's head was cut off, but they bled to death over 3 hours after their head was cut off. And yet, for whatever reason, the judgment that was obtained was only $100,000, but the other side had offered less than 75% of the 75% plus $1 of that, and that wasn't enough. What would you need to do at the time you make your settlement offer to help you prove down the road that your offer indeed was in good faith?
Comparable cases.
Yeah, you could basically put together a portfolio, I guess, at the time you make the settlement offer of why the offer you constructed was good and in good faith at the time you made it. And so that could include verdicts that have been issued to date on similar claims. It could include your evaluation, including you could go ahead and write up a memo to yourself regarding what the likelihood you think is of the opposing side obtaining evidence to achieve the elements of the cause of action, and what's and maybe even other bases. If there's a statute of limitations issue, which I've got a case here, that you think you're on the verge of it being you could say, well, at the time we thought that they had the cause of action had happened 2 days earlier, and we thought we were going to have a statute of limitations defense. So we thought we were going to win entirely. So therefore, we're not going to make a humongous settlement offer. And it is very permissible for the lawyer who is rebutting a claim of a not good faith offer to come in and give all the explanations for why the offer was actually in good faith at the time. For instance, it could potentially be, well, that was the entire amount of insurance that my client had, and they didn't have any money. So they made an offer for every dime they had available to them. You know, it can't be, you can't have a bad faith offer if somebody's given up everything they have. I don't think, arguably. But anyway, so that can be a big subject matter that is then appealable. Does anybody know upon what basis a denial after the statute is triggered, trial judge listens to the evidence regarding the presentation of evidence, and then it gets disallows the attorney's fees? On what basis is that reversible? What's the standard of review? It's actually an abusive, I mean, very close. It's an abusive discretion standard. So, and let's see, I believe that is the holding in Case Metrics versus Sherpa Web Studios, 353 Georgia Appeals 768, 839 Southeastern 2nd 256, 2020. And if it's not that one, I'll cite it at a different time. But basically, if the trial court makes its decision after giving full consideration to everything the trial court has seen during the course of the litigation, perhaps the motions for summary judgment were filed and all that, and if they conclude that the offer that allegedly triggered 9/11/68 was not in good faith, then the appellate court will be loath to change the ruling of the trial court. So let me mention 9/11/68E, and then we'll work through other observations that I made regarding 9/11/68. This is really a two different statutes in one, as far as I'm concerned. There's everything we've talked about so far, which is the conference of this offer, the response or rejection, the success or lack of success of the party that made the offer. And then there's the how do you prove it up, and how do you undercut the rights of the other side in the event they succeed. And then there is 9/11/68E. Well, this one catches people by surprise because it actually gives the opportunity for any prevailing party, whether or not they've ever sent a 9/11/68 settlement offer, to make a motion at the end of the trial asking for the finder of fact, which would be the jury if it was a jury trial, or a judge if it's a bench trial, to make a determination whether, in a bifurcated trial, to make a determination whether there were frivolous claims that were asserted during the course of the case, or frivolous defenses that were raised, and the way it's actually, I'll just read it because under this subsection, frivolous claims shall include but not limited to a claim, defense, or other position that lacks substantial justification, or that is not made in good faith, or that is made with malice or a wrongful purpose, as those terms are defined in Code Section 51-780. So what does that tell you about this? That means you get to do your essentially you get to do your 51-780 case, at least against the parties that are in the court now, rather than having to bring a separate lawsuit down the road. Okay? Before the jury that just voted in your favor. So that could be really good. A claim, defense, or other position with respect to which there existed such a complete absence of justiciable issue of law or fact that it could not reasonably be believed that a court would accept the asserted claim, defense, or other position. What does that sound like? What statute? 9/15/14, exact same standard. Or a claim, defense, or other position that was interposed for delay or harassment. What does that sound like? It's 9/15/14 also. So here you are, here you decide, oh, old Judge so-and-so's, who's dear friends with my opposing counsel who just lost, is never going to rule for me under 9/15/14 in a motion subsequent to this case. So I'm going to have the jury decide this. The jury that just loves my client, just gave me this great verdict. I'm going to have them decide whether the positions taken by the other side were frivolous or interposed for delay. Now, it specifically says, however, damages awarded may include reasonable and necessary attorney's fees and expenses of litigation. What does it not say when it says damages awarded may include reasonable and necessary attorney's fees and expenses of litigation? Does that mean what they don't include? No. So presumably in a bifurcated trial, you could have the finder of fact conclude that the opposing party caused all these other damages too by reason of their frivolous litigation efforts. Yes, sir.
So under that scenario, though, are you going to have to put on evidence of specific claims or defenses that were frivolous and tie your fees and damages to those specific frivolous actions?
Yes, I believe you would have to do that. You would basically have to present before a jury what you otherwise would present in a 51-780 case or a 9/15/14 motion. And you would have to tie. Now, 9/15/14, you can't recover any extra damages. 51-780 at SEC, you can recover additional damages, and you can also recover it against people other than the opposing party. So let's say you have a party who's the opponent who is not likely to be able to pay any more than the judgment you just obtained by way of your verdict. Do you want to do a 9/11/68E motion or second trial against that same party? Or do you want to bring a separate case and add their attorneys and all their co-conspirators in the case? It's a big question. But on the flip side, if you have a humongous opposing party that can pay anything you can win, then you might go ahead and tee it up before you're already prejudiced, for lack of a better description, jury and try to get it resolved then. It goes on in subsection E3, a party may elect to pursue either the procedure specified in this subsection or the procedure specified in 9/15/14, but not both. The only thing is in OCGA 9/15/14, you can't get any extra damages. So this would appear to provide extra benefit that you might not get under that statute. So while we're talking about this, I will bring up a brand new Georgia Supreme Court case, Junior versus Graham, which is 313 Georgia 420, 870 Southeastern 2nd 378, March 8, 2022, with Justice who wrote this opinion? Justice Bethel writing. And this was a case where the question was, if the plaintiff recovers under O.C.G.A. 13-611, but the same plaintiff also had served a normal offer under A, B, C, and D of 9/11/68 to the opposing party and had achieved more than 125% of that offer, then can the plaintiff recover both their full post 30-day recovery of attorney's fees and expenses under 9/11/68, and also everything they sought and got a verdict for under 13/6/11. And the Georgia Supreme, and in that case, it was a humdinger for the plaintiff's attorney. They had made a $600,000 settlement offer to the defendant. They ultimately got a $1.2 million compensatory verdict. They had a 40% contingency fee, and that was determined to be the reasonable value of their attorney's fees under the 13/6/11 claim. So whatever 40% of 1.2 million is, it's nice, very nice chunk of change. And then after they got that verdict, they moved for an order under 9/11/68. And the Georgia Supreme Court held that 9/11/68 and 13/6/11 are completely separate recoverable claims. That 9/11/68, they say, is a sanction against parties for not acting reasonably in underlying litigation, which I think personally is, I would argue, is a stretch, because you're automatically being asked to discount your lawsuit by a large amount, regardless of whether you're the plaintiff or the defendant under 9/11/68. And that 13/6/11 is a tort relating to the underlying transaction between the parties before the lawsuit is brought. And therefore, the 13/6/11 is damages for everything that happened before the lawsuit, and 9/11/68 is everything that happened after the lawsuit and after the offer was tendered, et cetera. So sure, you can recover both, okay? And basically, they just went through statutory construction. They said the fact that 9/11/68E does say that you can't do 9/15/14 and 9/11/68E, but the first two sections of 9/11/68 don't say you can't do 13/6/11 if you're doing 9/11/68. So therefore, if the legislature had wanted to exclude 13/6/11, they would have put that in there. And since they didn't put it in there, it's got to be a double thing. Now, what if you also have not only bad faith in the underlying transaction, or causing of unnecessary trouble and expense, lack of a bona fide controversy, and you did a 9/11/68 offer, and you had frivolous and obstructive activity by the opposing party throughout the course of the litigation? What can you recover under 9/11/68E? Which is yet for another purpose. It's for attacking frivolous and unfounded litigation tactics. You can recover a third time. So if the plaintiff in this case had the right facts with respect to frivolous activities, or the activity with malice by the opposing side during the course of the litigation, they could have gotten their $1.2 million plus 40%, plus another 40% of the 1.2 million. So if you can do that, you will make your client very happy, okay? If it happens against you, Lord help you. So that's Junior versus Graham. KSSR Properties versus Crown Castle Fiber LLC, just decided by the 11th Circuit this week. This is 2022 U.S. Appeals Lexus 19539, 2022 Westlaw 2761752, July 15th, 2022, 11th Circuit Court of Appeals. In this instance, Bell South got sued for having underground cables allegedly hidden within the underground area where a real estate developer bought some property. The existence of those cables and such allegedly caused a couple of $1 million of delay and loss associated with the development of the property. Bell South made a modicum of a settlement offer, something like $15,000, to the plaintiff, saying, "Hey, we're not liable for this, and there's a statute of limitations problems, and we're making this settlement offer to do away with this case." The case had two components. It had tort claims, and then it had a claim of I think it was a request for injunctive relief for them to move the underlying underground obstructive things. And the question for the 11th Circuit was, which triggered my mind. I said, "Hey, you must be able to bring this in federal court." Was whether Bell South could recover where it had two different torts. It had a tort and it had a non-tort case against it. And the Court of Appeals held that, yes, under Court of Appeals decisions in Georgia, the Georgia Court of Appeals, that mixed tort and non-tort settlement offers can give rise to liability under 911-68 for situations where both the tort and non-tort equitable claims, when the party's non-tort claim was entirely premised on the allegations contained in their tort claims. And here they cited, and this is why I was asking about the physical precedent issue a minute ago, they cited two Court of Appeals cases, and they said, well, the Court of Appeals of Georgia has decided this. The Georgia Supreme Court has not decided it, but since there's good precedent at the appellate level in Georgia, which has not been reversed by the Georgia Supreme Court, then there's no reason for us to certify a question to the Georgia Supreme Court. And they cited the Hillman versus Board, B-O-R-D. Hillman has two L's. Court of Appeals of Georgia, 2018. It's 347 Georgia Appeals 651, 820 Southeastern 2nd 482. Like I said, 2018, where it was a similar case, and the Court of Appeals held that in a mixed tort, non-tort settlement offer, if it's appropriately drafted and has all the elements of the 911-68, and it's entirely based on the same facts as the tort claim, that a party can recover for both tort and non-tort related attorney's fees. In this instance, there was a dissent by Judge Barnes saying that, well, the statute says torts. This is not a tort. The second claim is not a tort. This shouldn't apply. That the Court of Appeals is stretching the statute beyond its intent. And it also cited, say I've had that other case here. It cited, of course, they leave out the case name the second time it's mentioned, right? Well, it's 325 Georgia Appeals 361 from 2013, and this is the Canton Plaza Inc. versus Regions Bank case of the Georgia Court of Appeals, where it says, which involved an offer of settlement under 911-68. The Court of Appeals approved the defendant's attorney's fees after the defendant made the mixed tort, non-tort settlement offer. So basically, the 11th Circuit concluded that, yes, you can do that, and they awarded $350,000 or so of attorney's fees to Bell South for having allegedly been wrongfully sued by KSSR, where KSSR lost on summary judgment with respect to a statute of limitations issue. But that was a piddly settlement offer in amount, but they said, well, it's not bad faith. If you've got a statute of limitations defense that's good, then making a small settlement offer doesn't make it automatically bad faith. So, questions regarding all this babbling and comments? Does it make anybody nervous? The one thing I failed to mention is there's always the seminal question: if I make a 9/11/68 offer, am I prepared to receive one in response? And if I do receive one in response, where am I going to tell my client they ought to go ahead and settle? And I will say I had one a couple of years ago where we got a pretty darn good offer long before we knew all the facts from the opponent, right with the answer to the complaint. And I really give a lot of credit to the defense lawyer, and I've talked to him about this. I thought that was a brilliant and wonderful move. My client, however, was very wealthy and very mad, and he just didn't care that they had made this settlement offer because he wanted twice as much money. And lo and behold, by the time we did some discovery, we got another 9/11/68 offer for more than twice as much money, which we did accept. So it worked for the defendant belatedly, and it worked for the plaintiff because he was he had thick skin, I guess is one way of putting it. But otherwise, you have the potential of putting an individual in real jeopardy by telling them, oh, just turn down that offer. That's not enough, because it's the client, not the lawyer, that can get tagged under the statute. So any questions online or comments? All right, we're going to wrap it up. Thanks so much for being here. Y'all out there in the world, remember, we're not providing legal advice. Don't use my words against me. And we will see you next month.
Thank you, Henry.